This week on Dialogue, funding justice. Welcome to the Woodrow Wilson Center in Washington, D.C. I'm John Molesky. Each week, Dialogue explores the world of ideas and issues in international affairs, history, and culture. This week, we present our annual Law Day collaboration with the American Bar Association's Division for Public Education. Our guest is Christine Durham. Christine Durham has been a member of the Utah Supreme Court since 1982. Justice Durham served as Chief Justice and Chair of the Utah Judicial Council, the administrative governing body for the state's court system, from 2002 to 2012. And she joins us on Dialogue today. Welcome to Dialogue. Thank you for joining us. So you just flew in and your arms are killing you, as the old joke says. Let me ask you, Justice Durham, I know that you have said, because we've had an opportunity to speak before we began recording, that you don't believe you have a funding problem in Utah. But looking across the country, what's the landscape look like?
Actually, the landscape is pretty grim in many parts of the country. One of the things that we've been measuring through the work of the National Center for State Courts, for example, are the numbers of court employees who have been furloughed, incursions on salaries, including judicial salaries, as well as staff salaries in some jurisdictions, actual court closings where clerks' offices, intake counters, and courtrooms are shuttered for one or more days in a week. That, of course, has led directly to delays in jury trials, to delays in civil cases. The statistics with respect to that are pretty alarming when looked at in the aggregate. Now, some states are in different positions. Our state has taken major budget hits, but because of the control we have over our planning, we've been able to manage those changes in a constructive way without those kinds of draconian measures. But in states like New Hampshire, Florida, California, I mean, there have been real crises in the ability of the state courts to just do the daily business of the people, and that's discouraging.
That word, crisis, can you quantify that for us? What is actually happening? How do we know it's a crisis? What are we losing? What's at risk?
Well, it's very difficult to quantify that because the inability to get disputes resolved in a timely manner at court affects such a broad spectrum of potential litigants. On the commercial side, you have small businesses who can't get their debt collections completed, and they can't get paid, so they've got financial problems. Then you have victims of domestic violence and people who are in family dissolution proceedings who may not suffer financially from the lack of prompt response by the justice system, but suffer nonetheless. And sometimes public safety can be placed at issue, and people just experience enormous consternation at not being able to get on with their lives.
So everything from technical difficulties to life and death matters.
Precisely. Now, the state of Florida had a very interesting study done about 4 years ago, and they made an attempt to quantify what it meant to have certain kinds of delays in the court. And the estimate was in the billions of dollars. Now, people are critical of the methodology, and actually there's a new paper that's just been published by the RAND Corporation done on automobile accident cases in California, where they make an assertion that the lack of funding isn't having an impact on litigation, but their sample is so discrete. It's people with choices to come to court rather than the effect on people who don't have a choice to come to court.
Those billions in losses, whose losses are they?
Well, they're losses to businesses, they're losses to the economy in general in terms of being able to move commercial activity through the courts. If banks can't foreclose on houses and get those houses back into the markets, or if people who own the houses don't get an opportunity to assert their rights and their ownership, that causes losses in every direction. People, for example, who have experienced personal injury or contractual losses, who can't get remunerated for those losses, they're going into debt in terms of their medical expenses and the people to whom they owe money. And it's a domino effect. But I wouldn't want to assert that we have a foolproof empirical lock on those losses. To some extent, the data is still somewhat anecdotal.
Sure, that makes sense. But the timing of all of this, does this mirror the nation's economic downturn, or this precede it, or is it a symptom
No,
of it?
absolutely. It's clearly a symptom of it, in my view, at least. State governments, of course, have been hit very hard in terms of revenues with the recession over the last 4.5 years. And when revenues are down, budget cuts hit. In my state, over the last 4 years, we've taken approximately a 15% reduction in the amount of money going to the court's budget. And that's modest compared to some other states. Arizona has been hit much harder than that. Florida's been hit harder than that. New Hampshire's been hit harder than that. I mean, cuts in the neighborhood of 20 to 30% of budgets, which start out as only, on average, between 1.5% to 3% of total state budgets. The other problem is that state courts, and courts in general, are personnel driven. I mean, that's what the money goes for. The money goes for, obviously, the facilities, but the rest of it is in personnel. Mm-hmm. It's in judges' salaries and staff salaries. So when you're taking those kinds of hits, you're having to let people go, and they're not there to perform the services that need to be performed.
The unevenness of the problem across the country, what are the funding mechanisms that make it so? I think about how education is funded, and you have similar problems because it relies on local tax rates, and so it changes from locale to locale. Within a state, even within a county, you could have discrepancies. What is the patchwork quilt of funding the justice system that leads to similar inequity?
It's equally complicated. We talk about state court systems, but in many states, there is no such thing. You look at New York or
Texas,
for example.
It's not centralized from the State House down.
It's not centralized. You'll have state funding possibly for the appellate courts, but then all of the trial courts, every level of trial court will be funded by some different configuration of local government. Mm. And so in some states, they didn't feel things so much at first because it was the state budgets that were being cut. And so the legislatures just kind of passed things on down to local government. But then, of course, local government started to experience the same loss of revenues, and the cuts took place across the board. But the differences in funding mechanisms does mean that there isn't a single easy solution. I'm very happy in our state, and one of the reasons I think we are doing well is that we have a highly centralized governance system, and all of the state courts are completely funded by the state and by the state legislature.
How unique is that?
It's pretty unusual. Other states have partial state funding. Some are working very hard to increase the responsibility at the state level. I mean, you can understand historically how it grew up that way. Courts were local affairs. They served local communities. They were not large organizations. They didn't have a lot of complexity. But now when you look at the millions of cases that are filed in state courts every year, and I have to get in the fact that for the last year we have numbers where in the federal courts in the United States, and I think this is from 2009, you had approximately 385,000 cases filed in all of the federal courts in this nation. The number for the state courts in the aggregate was in the vicinity of 47 million.
385,000 versus 47
million. The state courts do more than 95% of the judicial work in this country. So
is there any federal money to support that?
Very little, and that's one of the things that the Conference of Chief Justices and the National Center for State Courts, who speak for the state courts as institutions on a national level, have been trying to educate Congress about the need for support, especially in view of the fact that Congress, as in other arenas, is somewhat prone to giving us more work to do.
The old unfunded mandate problem.
Exactly, exactly. So, you talk, for example, about the needs for court security. As you might imagine, as is true of American society in general, courts have really experienced an increased sense of vulnerability on security-related issues.
Are you talking about the 9/11 effect, essentially? That what are the changes in Utah that you've experienced firsthand in response to that?
Well, we have been fortunate in being able to partner with Homeland Security and with the state law enforcement agencies, but we've also undertaken over the last 10 years, we've hired our own security officer for the court system who's been doing security audits on all of our courtrooms throughout the country. Actually, state courts are not so vulnerable to terrorist
Well, I'm wondering,
attacks.
is this a real threat or is this a perception
No, the
of...
terrorist part of it is not of concern. However, given the kinds of people and the kinds of problems who spend their time in courthouses
Well, you're dealing with
around the
criminals.
country, you're dealing with criminals, and you're also dealing with people who are at extremely stressed points in their lives. Actually, the research suggests that the most dangerous litigants are disgruntled domestic relations litigants, people who are whose lives are falling apart.
Makes
and
sense.
who blame the lawyers and the judges. And if you look around the country at the judges who have been attacked and the court-related attacks, they have often been in civil cases, not criminal cases.
The model that you've used in Utah, which has allowed you to weather these budget cuts, can it be duplicated elsewhere? Is this a model that would work?
I hope so. One of the things that I've had the opportunity to participate in that's been extremely valuable is an executive session at the Kennedy School of Government at Harvard. And they looked at state courts as institutions, and one of the things we studied was governance and tried to identify some basic principles of governance: control over one's resources, the ability to speak with a single voice when dealing with the other branches of government. And those principles are getting, we've published, there have been some papers published, and they're getting a lot of attention around the country. Court leaders, court administrators, and judges are looking at ways that they could revamp their governance systems to give them more control over their own destiny.
One thing that I'm having a hard time wrapping my head around is this notion that this isn't like cutting the budget for snow removal, right? Snow removal isn't constitutionally guaranteed. We're talking about holding back on constitutional guarantees for individual citizens.
Well, that is certainly my view, and I've had some interesting discussions. There are people who say, well, public education is a constitutionally guaranteed right in state constitutions. But of course, state constitutions, the vast majority of them have provisions, I think it's 37 of the states have, or 39, have provisions that mandate open courts and access to justice. And of course, in the federal system, that has been implied in the federal constitution that there's some kind of guarantee of a dispute resolution system to which citizens must have access. We've come to regard it as central to the rule of law. So I think that even in the hierarchy of constitutional rights, the guarantee of access to a justice system that will preserve the rule of law and the protection of individual rights takes priority, even over something like education, certainly over snow removal.
It depends on how much snow, I guess, right?
True.
No, but should this critical, fundamental function of American democracy not have some control over its own purse strings?
Well, it depends on what you mean by control.
I guess you can't print money, but short
no,
of that.
I mean, we'll never get to the point where the courts are going to be able to print money. And there's a sense in which it's very clear that the appropriation power belongs to the legislative branch. That's true in the federal constitution. It's true in the state constitutions. So I don't envision a utopia in which the courts could essentially print money or demand appropriations. But at the same time, I do think that court systems need far more control than is usual in the state courts in this country over the monies that are appropriated. And we need a much better system of educating state legislatures about the needs of the court and about the connection between the work that courts do and this fundamental function of democracy. I've been a little bit dismayed, even in my own state, when budget cuts were being imposed across the board. We, in my view, were able to make what I thought was a very strong case that because of our structure and because of the nature of the function we performed, we should not be lumped in with social services and other executive branch agencies in terms of taking flat cuts across the board. That was a really difficult sell. We were moderately successful in preserving what we needed to go on. But I really wish that state legislatures had a better vision. I mean, that if you talked about cutting the legislature's budget, I think they would see how essential a legislature is to a functioning democracy.
This education notion, you're talking about educating
Yes.
legislatures, but what about the broader public? What about, has the justice system represented itself well to the larger public?
You know, we work so hard at it. We do so much. People like former Justice Sandra Day O'Connor develop programs like iCivics, which we've instituted in our public schools. We've organized commissions on civic education. We write op-ed pieces. We testify before Congress. We do position papers.
And like the rest of us, you
speeches.
can't get anyone's attention.
I know. It's quite dispiriting sometimes to realize that at this stage in our history, and I'm not convinced that it's ever been any different in our history in this country, but that the ordinary citizen is more content to take for granted what has always worked reasonably well.
Is this the kind of thing where, unless you come into direct contact with it, it operates invisibly?
I think that's exactly true. What's interesting, though, is that when we do surveys of jurors, for example, they have very good impressions of the court system. They feel very positively about it. In fact, in our own, we do, and I think more and more courts are doing this across the country, we do regular user surveys to try to gauge how satisfied people are with their court experiences. And the people who actually come into contact with the system do feel good about it and have some trust and confidence in it.
And would be willing to fund it, presumably.
And would be willing to fund it, presumably.
Yeah.
But then you have, when we talk about the challenges to state courts these days, funding is very much at the top of the list, but close behind and connected is this whole issue of public trust and confidence and our methods of judicial selection and the degree to which special interest money has started to permeate the selection of judges in those states where they are elected, and even in some of those states where they're appointed but sit for retention election, to wit, Iowa. You're starting to see a suggestion, I think, and there's some research that backs this up, that people are worried about the independence and the integrity of their court systems.
Why is judicial independence important?
Well, it is key to impartiality. What we want and what the rule of law requires are fair and impartial courts. And if those courts are staffed by judges who are not impartial and whose lack of independence undercuts their ability to be impartial, you are eroding the whole premise of that system.
Would it follow to suggest that you think electing judges is a bad idea?
I do personally think that electing judges is a bad idea. I think that it turns judges into politicians and that it requires them to raise money, which immediately raises the specter of their being beholden to the people from whom they have raised the money. And my own sense, I realize that it's deeply ingrained, and it's ironic that the election of judges was actually instituted in the mid-19th century as a reform to the then extant appointive system that people thought was corrupt. So you have a reform which, in my view, has now reached a point where
swing back the other
it needs reforming again.
The whole notion of how democratic the courts are comes up
Yes.
as a result of this discussion. Do you want a court made up of appointed elites, Or do you want a court that is more mirrors the larger democratic whole?
Well, there's something in between those two options, of course. We have in our state what we call a merit selection system, and it operates very much that way. There's a panel, a citizen panel, with citizens on it, lawyers on it as well, who actually screen applicants and make recommendations to the appointing authority. And then the people have a say when they vote on retention elections. But this whole notion of courts as democratic institutions, the tension's been with us since the founding of the nation, but I'm always troubled by the suggestion that judges are somehow unconnected to the democratic process because they stand outside the representative partisan portion of that process. Judges stand for the Constitution and the law, and the structure.
Even when the mob wants something different.
Even when the mob wants something different,
And
or even when the majority.
It is a pejorative. I don't mean
it's
it that
pejorative,
way,
but even when the
using
majority wants something different, it is the people who have enshrined our values in our constitutional documents. And so the notion that because the people's elected representatives on a given occasion might choose to pass a law that impinges on the more fundamental value enshrined in the Constitution, the notion that having judges decide that question is somehow anti-democratic isn't one that I'm willing to accede to. It's anti-representative.
What you describe as defense against the whims and passions of the moment.
Well, yes, and defense of the fundamental charter of the society. And so it's anti-representative in the sense that the people don't elect judges to decide cases the way the people want them to, as you say, in the moment. But judges are selected to decide cases the way the values in the constitutions that the people have enacted dictate.
What do you think it would take for this to get on the average voter's radar screen? What, in other words, how far, if we're already seeing breakdowns in the system, if we're seeing furloughs and doors shuttered and things like that happening now where people can't get the access that they need at any given moment, what do you think it would take for this to gain some momentum and capture people's attention in a way it's addressed significantly?
Well, there are so many entities and so many spokespeople who are working very hard on that issue across the board. The leaders in the state judiciaries have been, I think, in some respects, first and foremost, at least within their individual states. I mean, you see the chief justices in states like California and New York who are going to the people in the form of the legislature and who are also going directly to the public for purposes of education. My own sense, and it's been true for a long time, is that we need to do much more to pay attention to the citizenship education we give our children. I mean, civics education has become almost a shibboleth, but it's interesting. It's sort of where everyone ends up who cares about these issues, is the notion that it doesn't do to wait.
It's not only
until
math
crisis
and science.
time.
Right?
That's right. It's not only math and science.
This is not that I'm sure this mirrors a lot of what you've been saying, but I have in my hands the President's Proclamation for Law Day. And this one point I want to share with our viewers and listeners and with you. I'm sure you've already read it, but just in case you haven't.
Actually, I haven't seen it yet.
It just came out today. You were doing other things.
That's right.
Our courts are the guarantors of civil justice, social order, and public safety, and we must do everything we can to enable their critical work. The courthouse doors must be open, and necessary services must be in place to allow all litigants, judges, and juries to operate efficiently. And here's the kicker. Likewise, we must ensure that access to justice is not an abstract theory, but a concrete commitment that delivers the promise of counsel and assistance for all who seek it.
Amen. That's a wonderful. That's a wonderful statement. It raises the specter, though. Access to justice is an extremely complicated notion. Certainly, the courthouse doors have to be open, and someone has to be behind the counter to provide assistance and to take filings. But if you don't have the wherewithal as a private citizen to protect yourself against foreclosure of your home, against a collection matter, against an eviction proceeding, if you're a small business person trying to enforce a contract and you can't afford legal representation, you are also, in a sense, in a very real sense, being denied access to justice. And so that's another layer to this problem when we talk about being the guarantors. There's every reason to believe that more and more Americans are falling below the level at which they can get basic legal services to solve the basic legal problems that everyone is going to have in the course of their lifetime. We estimate in the state court system that close to 75% of all domestic relations litigation, so that's divorce, family dissolution, custody, child support, are cases in which one or both parties are unrepresented by lawyers. And whereas one would hope that, a family dissolution would be a straightforward, intuitive process, it's not. It involves all kinds of financial issues. It involves the declaration of really important rights in terms of access to children and decision making. It involves the allocation of debt and property. Many of those are complicated legal questions, and people need help, and it's very hard for them to afford it. So that's another problem, and it's a problem that state legislatures, for example, are ill-equipped to deal with in this era where they're, just basically struggling to find enough money to keep the courthouse doors open.
Well, thank you for sharing your insights into this very important issue, even if it isn't on enough radar screens currently. Maybe you helped move the needle a bit today.
Well, thank you very much for
us.
inviting me, John. I've enjoyed it.
A pleasure. Thanks. We'll return next week with another edition of Dialogue. Until then, for all of us at the Wilson Center, I'm John Milewski. Thanks for joining us.
We'd like to hear from you. Please send your questions or comments to dialogue@wilsoncenter.org. You can also follow us on Facebook. Search Dialogue Radio and Television. Our host Twitter feed is twitter.com/John Milewski. Dialogue is a co-production of the Woodrow Wilson International Center for Scholars and MHZ Networks. Dialogue is available via broadcast, cable, satellite, and telco on MHZ Worldview throughout the United States. To see how to watch where you live, visit www.mhznetworks.org.